Thank you, counsel. Justice Thomas? Justice Alito?
No.
Justice Sotomayor?
You know, I don't see any state that defines intellectual disability this way. I certainly don't see, or to prove it this way, I don't see anything in Alabama's law that suggests it's following that rule. You're making something wholesale up, and you're claiming that there's disagreement in the lower courts. I don't see all that much disagreement. In Smith's table on page 17 of the appendix, he has cases from across all the states. And although you try to reap some confusion among them, they all seem to be following the method the district court here followed. And we announce a new rule. We've announced more confusion into an area where there's pretty standard procedures. They do exactly what the district court did here. I have no case that I have found, and I want you to find one state case that applies the rule as you've articulated it.
Byrd versus State clearly states that the offender has the burden to prove by a preponderance of the evidence that his IQ is 70 or below.
There is no dispute about that. Assume I take that as a given. We didn't grant cert on that because that really wasn't disputed anywhere. So where's the rest of what you're saying? That states determine prong one based solely on IQ scores and some statistical unknown method of creating a medium composite score.
There are different methods. Some state courts have taken the average or the median, or they've simply said the scores are consistently above 70, and so it's an offender's burden to come back and overcome that with a statistical method. It's not Alabama's burden.
Tell me name one court that has held that it's up to the defendant to prove the first prong by a preponderance of the evidence with some statistical measure. It's not what I see. I have not found one state case that has required that. And now you're going to put in a new requirement that's actually even more complex than what states have been doing.
Well, Hall itself said that evaluating multiple scores is a complicated endeavor.
I am asking you for a simple answer. Name one state case that has made your prong one dependent on a statistical analysis of what somehow either an aggregated, medium, composite, I don't care what word you use, one state case that has required that.
Well, I think courts haven't needed to go that far because offenders haven't come with a method. They haven't satisfied their burden in these cases.
But they have granted relief to others without it.
Not in Alabama. Sometimes the 11th Circuit will do that, applying this lowest score rule, and there is a division of authority. The 8th, 9th, and 11th Circuits look at the lowest score alone and say that it represents...
They may well be wrong, and I think they probably... I haven't looked at those cases carefully enough to say whether they made error or whether you're characterizing them in a way that's not quite accurate, like here. The 11th Circuit made clear, as did the district court, that it wasn't relying on just the one law score. There were 3 scores that were within the SEM of 70 and below.
Hall said that IQ is a measurement that has statistical properties which we can evaluate, and that's why we take into account the standard error of measurement. The experts in this case are also telling us...
One case that has required plaintiffs to come in with the statistical mathematical certainty of a particular number.
Not certainty, but a preponderance of the evidence. And
Thank you, counsel. Your answer must be
Justice Kagan?